there's a bit of crossover here with fixtures. So when a chattel, which is a lawyer's word for a thing, when a chattel becomes fixed to real property, it actually becomes part of that real property. So if I start out with some goods, they become affixed to a house. Those goods as a fixture are now real property, so the PPS doesn't apply anymore. Anyone here supply goods in the construction industry? Okay, so you guys are well aware of this concept. It's front and centre. We had a situation about a month ago, a client who's a pretty big supplier into the construction sector, doing a lot of stuff like this: ovens, sinks, dishwashers, items that are going into commercial and residential towers. We received a phone call. They'd just supplied $100,000 worth of stock 2 days ago to one of their customers, and they found out today that that customer has just gone into administration. They also found out that the administrator was trying to do a deal with the developer, which would mean that their stock was about to become a fixture and turned into a kitchen. So personal property, real property, rights, no rights. Who doesn't like the idea of losing $100,000 worth of stock to a liquidator? Okay, so what's the first thing you're going to do in this situation? Put yourself in this client's shoes. What would you do? What's the first thing you're going to do? You call a really good lawyer really quickly. Look, what we want to do is, firstly, we know our stock's at risk, so we want to try and protect that. So the first thing we did for this client was we said, hey, we want to do a stock take, we want to do a stock take now. And we got our client in there and we did a stock take, because until that point we didn't know whether the goods were still goods or whether they had become real property. We didn't know what the extent of our rights were. And if we didn't ascertain that, by the time the 45 days had ticked over, it would have all been gone. So that was the first thing that was crucial. The second thing that we did was that we objected to the administrator dealing with the goods. Now, administrators do have an express right to deal with goods in the ordinary course of business during administration, but that doesn't mean you need to sit there for 45 days on your hands and do nothing while your goods are turned into someone's kitchen that you can't touch. So what we did was we said, those goods, we object to you dealing with them. If you deal with them, we're going to hold you liable for damages, and we consider the type of deal you're talking about doing as not being within the ordinary course of business. That turned into a fight, funnily enough, but between the strategies we adopted and some practical strategies that our client did in line with what we were doing, out of the two different sites, on one site our client got almost all their stock back, and on the other site we were able to do a deal to get paid 90 cents in the dollar. So acting quickly and being able to run these strategies really meant the difference between having personal property rights and not having any rights. We would have had a right technically to proceeds, however there weren't going to be any proceeds. So our lessons coming out of this: firstly, we don't want our goods to become a fixture because we'll lose our rights. Someone goes into administration, we want to do a stock take, and we also want to object to the administrator dealing with the goods. We won't always get away with that. However, if you talk to someone who knows what they're doing, they'll run an angle on it, or if they can't run an angle, there can be other strategies that get put in place.